Welcome to everybody that's already here. While I'm doing this, Nicki, you want to tell them a little bit about Appleton Reiss?
Sure. We are a community association law firm. We solely represent community associations. We do not represent any individuals. The starting partners of the firm, founding partners, was Michelle Reiss and Eric Appleton, and I joined these folks in January of 2020 after I left FL Legal Group. So it's a very structured way of representing community associations. We do document amendments, collections, day-to-day legal opinions, general counsel work, and also litigation work for the association. I've been myself practicing for over 20 years. Of that 20 years, it has been about 15 years in community association law. So I just kind of fell into it, but it was a good fall, to say the least. So if anybody ever has any questions, please let me know. I'd be happy to answer them. You can reach me by email at nasmer@appletonreiss.com.
We've had some questions submitted via email, also directly to Nicki, also to BMI, and then also in our registration. So we'll be going over these questions today. You can also, if you have any questions, there's a Q&A button down there at the bottom, or you can place it in chat. I'm going to be monitoring both Facebook for questions and also the Zoom, so bear with me if I'm slow to react to your questions. I will get to everybody though. We have time. And with that being said, Nicki, you and I were recently talking about 55 and older communities.
Yes.
And there was a law that came out on July 1st regarding this. Mm-hmm. So I was going to let you talk a little bit about that.
Sure. This was a proposed amendment that passed effective July 1st, 2020. And it actually amended statute 760.29 subsection 4. Of the Florida statutes, and it deleted the requirements for, quote, housing for the elder or older persons community, which is considered 55 plus communities, to register with the Florida Commission on Human Relations. So the previous law actually required the registration of the association to be updated every 2 years, and that's not required anymore. So this change will actually help the association with time and resources so that they don't have to do this every 2 years. You still have to meet all the other legal eligibility requirements to have a 55 and over community. And these requirements that at least 80% of the occupied units be occupied by at least one individual that is over the age of 55, and that the appropriate age verification procedures are still followed and updates are in place. You got another question, Carrie?
Oh, I'm sorry, I was on mute. Yeah, we had a question come up. We had a question come up not too long ago, and it may be a bylaw-based answer.
Okay.
You know how sometimes snowbirds will be in a community only 6 months out of the year, and let's say they have a parking spot that's closer to the buildings. During that 6 months that they're not in their unit, can their parking be assigned to somebody else, or is that kind of a,
So parking,
how would that work?
you have to look at the declaration. It depends. Remember, parking spaces can be considered limited common elements, and what that means is, and I'm sure everybody knows this already, but just to clarify, limited common elements are usually assigned to a specific owner or a unit, and if it is part of their limited common elements, either per deed or the declaration, then we wouldn't be able to assign it to anybody else. Say the example is you don't have enough parking spaces in the community and you want to try and use it while maybe one of the snowbirds is away. As long as you can come to an agreement with the owner and they're okay with the use of the parking spot while they're up north, there shouldn't be a problem. However, you can't force someone to do this not contained in the declaration. And normally your parking spaces are considered a limited common element, whether they be attached to a carport or they're assigned spaces. But if they're unassigned spaces, then you don't have as much of an issue to deal with.
Okay. Does a condo unit owner have the right to prohibit anyone? Well, can they prohibit a specific person from parking in that spot? I guess that was one that was, you kind of already answered it.
Right, yeah. Go again, if they're assigned specific parking spots, and they're considered limited common elements in the declaration, then no, they wouldn't be able to do that. Again, you'd also need to look at the declaration to see if the parking spaces were actually assignable.
Right, okay. So here's an example. I own the top unit of a 2-story building. Heavy rains caused roof damage, which caused significant ceiling damage in my unit. The property manager quickly sent a roofer to fix the exterior problem. They will provide service to replace my ceiling sheetrock, but will not pay for ceiling paint. Why shouldn't it be made whole? I was told that Florida condominium law does not allow the association to paint. Is that accurate?
So we need to look at the statute, the insurance statute. If it's considered an insurable event, which in this case, there was a roof leak and that would be considered an insurable event. The unit owner and the condominium association have 2 different policies, and the condominium association's policy covers all of the common elements of the building. The unit owner's coverage should cover everything inside the unit. Now, the statute specifically lists out what the homeowner is responsible for and what the association is responsible for. So if you have a situation, and this always happens, if you have a situation where you have a leak and it's trickling down the building, that would be considered an insurable event. The coverage on the unit owner's property would cover everything in there. And if there's any leaks within the wall or the pipes of that nature or under the slab, that would be the association's responsibility. Now, there's questions in regards to who's responsible for paying the dry out, because the statute is silent on that. And this is when you call your rescue people out and they put all the fans everywhere to dry everything out. What I normally do in that situation is I will negotiate with the owner, and advise them that the law does not provide that either party is responsible for it. So I'll try to split the bill with them, because you don't want to be in a situation where you're leaving this up to the homeowner, because the mold could spread quickly and then you're going to have a problem in multiple units. So it's better to do the dry out so it doesn't affect neighboring units. And then try to negotiate with the owner as far as splitting the bill or something to that effect. Drywall is another issue. The drywall is the responsibility of the association, not the painting, and not wallpaper or any type of finishing on the wall. So if the plumber comes in and has to drill a big wall, a hole in the wall, and the drywall needs to be replaced, in the situation that you gave me, Carrie, you would be required to replace that drywall because it is the association's responsibility. And I get a lot of owners that are very upset about this because, you know, they come in, they patch up the drywall, and they have a wall that doesn't have either painting or wallpaper, but the association is not responsible for those finishes.
Okay, now this one goes back to the July 1st amendment that we were discussing originally. And Susan is asking, does that mean that nothing needs to be done to prove that you meet the 80% of those over 55?
No, that does not mean that. You still have to provide proof of it. You just don't need to register with the Florida Commission on Human Relations.
All righty. So let's get to this question. My board of directors wants to amend our rules regarding the minimum lease term. What notice of this board meeting should be sent to the owners, or is required to be sent to the owners?
So this is a two-part question. You know, all your board meetings have to be posted at least 48 hours in advance in a conspicuous location. When you're proposing to amend your governing documents, and the rules are considered now part of your governing documents, you would need to give the members 14 days notice of the proposed amendment, because they need to have a sufficient time to review the proposed amendments and how they are, and how they're going to affect them as well. So regular board meeting, 48 hours, but when you're considering an amendment, 2 weeks, 14 days.
Now, when you start amending bylaws, is this a long drawn out process? You have to give so many days notice to the unit owners before you do this type of thing. How long could it take to get certain items put in your bylaws? And is it something that you should wait, and if you have several things you want to change, just do it all at once?
So the way that
I'm asking for newer board members.
I'm sorry, go ahead.
I was saying I'm asking for newer board members.
Okay, so here's the way that I handle amendments. Because some of these documents are really old and they haven't been touched in decades. So what I would normally do is review the entire set of governing documents, and then I'll prepare a letter to the board advising them of what I think needs to be changed, either because the law has changed, their documents are outdated, or they conflict with each other. You know, you have to be mindful of the fact that if you have conflicting paragraph, and it does happen a lot, between your declaration, your bylaws, your articles, and your rules. Remember, the hierarchy is statute, declaration, articles, bylaws, and then your rules are way at the bottom because they do not require a membership vote. So you can't have your rules conflicting with your declaration. So if you're in a community that does not permit rentals under the declaration, you can't change your rules to allow rentals because it conflicts with the declaration.
You know, I was just going to say, you know, we had given a class earlier this year on Airbnbs, and anyone that's going in to change their bylaws now needs to discuss that as well, the Airbnb options when reassessing their amendments.
And I taught this, I teach this class as well, the Airbnbs, and unless you have specific restrictions in your declaration to prevent or deny the use of the property for short-term rentals, you're not going to have any remedy to have these removed or the tenants removed. So I usually draft these amendments to include the name, you know, VOB or Airbnb or any short-term rental that is advertised, or, you know, that is less than a week. But you do need to have your declaration reviewed because there may be a lot of things that need to be amended, either because the law has changed or it just doesn't clearly establish what the set of rules are, and you can't make an inference or any type of a guess as to what it might be if it's not expressly stated in your governing documents. I have a query from David Middleton.
Okay.
It says, if bylaws have been filed with the county, do all new amendments have to be filed to be enforceable? Before you do any amendments, all of your governing documents, your declaration, your articles, your bylaws, they are all recorded in the county where the association is located. So first, they have to be all recorded in order to be enforceable, okay? If you want to amend your bylaws or if you want to amend your declaration, you only have to amend that specific document that you're changing the language on. So yes, you do have to record them. And if you do not record them, they're not enforceable. Once they're recorded, then they're considered in effect.
Okay. Now we're going to go to a very popular topic and possibly a sore subject. Emotional support animals. A new law has recently passed, which is supposed to cut down on bogus requests. When does this law take effect and what are the details?
So the law went into effect July 1st, and we have more leeway to ask owners for documentation or information regarding the disability that's attached to the animal itself. Now, this is a very hot topic right now, and there are a lot of attorneys who practice in the area of disability that are taking on cases on a contingency basis because they know that the association's insurance is going to pay for it. I just recently had an inquiry from another association where the management company had asked the owner who was requesting a support animal information about the dog. And she lawyered up, and now the insurance carrier wants to offer them some ridiculous number like $25,000, only because the association was inquiring about the dog, not even about the disability, just about the dog. So this law is going to put these people out of business who are preparing those certificates online where you can just log in and buy your certificate and be done with it. You actually have to get a healthcare professional's written explanation as to why the patient or the owner needs to have the animal and what correlation is to improve their livelihood.
Okay. My homeowners association recently posted new rules concerning the use of our community pool in response to the coronavirus pandemic. The board stated that if the rules are violated, the association has the right to suspend the owner's right to use the pool. Because the pool is a community pool owned by all the owners, does the association have the right to suspend an owner's right to use the swimming pool?
So this goes back to the emergency powers, and the condo and plan development chapter of the Florida Bar is actually drafting new legislation to clarify what those emergency powers are for the association. When Governor DeSantis actually entered an emergency order that we were under a pandemic, the emergency powers would click in for the board members, and they do have the right to suspend use of common elements during any type of an emergency or a declared emergency. It has to be a declared emergency. You can't just make up or assume that there's a certain situation that is an emergency requiring that the board take action. It has to be a declared emergency. in order for those emergency powers to kick in. So yes, it can be done, but once we're out of that emergency state, then they have to reopen the pool.
So this could also apply to hurricanes. After a hurricane has hit, we could go into a state of emergency there as well.
Absolutely.
Susan is asking, where do policy changes fall? Do they need to be noticed to the membership?
Policy changes, are we talking about rules and regulations or amendments to the governing document?
She did not specify, but she is online with us now. So Susan, if you could specify in the Q&A, we'll try to get back to that question here shortly.
Let me answer it both ways for you, Susan. If you are changing policies and procedures, and I'm assuming this means your rules and regulation, the board rules and regulations, the board meets and they would determine what amendments need to be made. And then the board would need to notify the members of the changes at a board meeting and produce copies of those changes as well. If you're amending your declaration, bylaws, or articles of incorporation, that's different because you have to get a membership vote to do that. Rules and regs, you don't need membership vote. Declaration, bylaws, and articles, you do. So the members are the ones that will be deciding on the proposed changes to the governing documents, and you must give them at least 14 days notice before the meeting with the proposed language in order to have it validly accepted.
Okay, next question was, I am a unit owner living in a community with a homeowners association, and I would like to know if a member of the board of directors who has been recalled, removed by a member vote, can run again for the board. Our membership, following all the proper procedures outlined in Florida statutes relating to the recall process, had this owner removed as a director earlier this year. Our governing documents do not state anything regarding this issue. Our election process will begin shortly with the annual meeting and election occurring in December.
Good question. Recalls, they're nasty. Let me put it this way. Let's say your board member is recalled in January, and your elections are being held in, let's say, November, okay? So he was elected on the board in November. He was recalled in January. Now that board member cannot sit on the board for the remaining term if he was recalled. But once the term is over, he can run for the election again. That makes sense?
Wow, that could get sticky.
Yeah.
Oh.
So even if you recall somebody, they could possibly get on the board again after the term expires.
All right. Next question. I live in a homeowners association community with 41 homes. I just received the notice of annual meeting, and none of the candidates for the open director positions are mentioned or listed anywhere. The owners never know who the candidates are until the annual meeting is held and nominations are made from the floor. The same owners end up getting elected year after year, and it seems like this should not be legal. Is it legal?
For homeowners associations, your election procedures are a bit more relaxed than the condo associations. The condo associations, you know, they have the notice of intent that you have to fill out in order to run for the board. I normally would revise the declaration or the bylaws, whichever one is applicable in this situation, to put down that the notice of intents are required. And you can be flexible with the time frame, because how are you going to know who's running for the board until you get to the meeting? But it is legal. However, there are better ways to do it so that you know who's running, and it would probably give you more insight as well. So I would recommend that the HOA amend their documents so that you can have that, but it is legal.
want to pause here for a minute and see if we have any questions that are popping up before we move on to the next question.
Oh, I have
Did
one.
we get Susan? Okay.
Susan, such as a collection policy. Okay, so we're talking about a resolution. So the question is, and correct me if I'm wrong, Susan, you want to change a policy, a collection policy, and let me know whether or not this was a resolution that was created and signed by the association. And it would depend also on the language that's in the resolution as to how it can be revised or amended. But yes, it is just like you would be amending the rules and regulations. It does not require a membership vote. And again, you have to give the members notice after the policy has changed. Let's say, for example, there was a change in the statute, and instead of 45 days for a homeowners association, they changed it to 30 days. So normally you would see either the 30 or 40 days in the resolution, and you could change it by doing an amended collection policy. So that is the way that you would revise or amend such a policy. Now, if it's contained in your declaration, again, you're going to need a membership vote. But under policies or resolutions that are implemented by the board based on their authority that's given to them in the declaration or bylaws, then they would be able to amend it. And be careful, because if the board doesn't have the authority to implement these type of policies, they could be unenforceable. You have to be able to have the authority to do it through the documents in order to implement policies. So let's say, for example, you have the assessment portion of your declaration, and it indicates that the board has the authority to implement reasonable rules and regulations regarding the collection of past due assessments. That language needs to be in there for them to actually do the policy.
What about during this pandemic, a lot of places are required to have people wear masks when they're indoors. Does the board have the power to say, okay, you can't use any of the common areas, including the swimming pool, clubhouse, yada, yada, unless you're wearing a face mask?
That would go also towards the local rules and ordinances that have been passed, such as Hillsborough County. Everyone's required to wear masks. And I would look at what emergency powers are still, in place. And if it is a safety issue, then yes, the board could require it under their emergency powers as well. So, but
okay.
If your local ordinances or your local laws require that you wear masks when you're out in public or when you're out at a restaurant, you could also require masks be worn inside the clubhouse.
All right. We got a lot of homeowners questions here for homeowners associations. My homeowners association is preparing to have the members vote on 4 different amendments to the governing documents. However, the association is proposing putting the 4 amendments to the owners in one vote. Take it or leave it. It was my understanding that the association was required to put each amendment to a separate vote, but I could not find that provision in the statute. Can they do this?
That's because there is no provision in the statute for it. Let me give you an example. You want to change your amendment procedures from 75% of the entire membership to a simple majority. That language is in all 3 of your governing documents, your declaration, your articles, and your bylaws. So in order for you to amend any of those documents, you need 75%, and you want to change all 3 of those documents so that they're consistent. I just had a recent amendment that I did the same thing on. We did it a take it or leave it, because you can't have one document say simple majority and you can't have the other document say 75%. So in the take it or leave it scenario, yes, you can do that. And there is no requirement under the statute that you separate them out. What I normally will separate out is any issues that are very contentious. For example, I would always have a separate vote on leasing. because there's a lot of investors in the community and they want to be able to lease their property. So that is always an issue of contention. And if you're doing a complete rewrite of the documents, then you would need to put in those separate items that you're changing in the declaration, which are contentious. And it's only because you don't want to have the entire amendment shot down from the members. You want to be able to pass certain provisions, even if they don't agree with the leasing provision or they don't agree with another provision that's being amended in the documents.
Okay, well, let's just take just a moment and do a brief check-in on our sponsors to say thank you for allowing us to have these webinars. Compliments of all of our chapter sponsorships, our chapter sponsors: Nature's Own Pest Control, Parking Lot Services, CPR Concrete Painting and Restoration, Appleton Reiss, PPG Paints, Mitchell Insurance Services, ACPLM, Fieldstone Landscape, LRE Foundation Repair, Yellowstone Landscape, BB&T Association Services, Down to Earth Landscape and Irrigation, Delta Engineering, Reynolds Painting Group of Florida, Centennial Bank, PCS Insurance Group, Florida Paints, and Crown Roofing. Okay. Are you back on full screen now after I did that? Nikki, what are you seeing?
My logo.
Okay. All right, let's go back to some more questions here. My homeowner, let's say, we said that one. Okay, another homeowner association is attempting to amend our governing documents. At the membership meeting where the vote was to occur, the board announced that not enough of the members had participated, and the board was continuing the meeting to allow members to vote. Is that allowed?
Yes, it is allowed. And let me clarify something, because a lot of these questions are geared towards homeowners associations. It applies also to condo associations. The governing documents, as far as amendments are concerned, and policies and procedures for the board, what I had explained previously applies to both. Now, Carrie, can you repeat the last part of that question?
She said that at the membership meeting where the vote was to occur, the board announced that there was not enough members to participate, but the board continued with the meeting to allow more members to vote. Is that allowed?
Yes.
Did I say that right?
That's actually a statute on point. Let's say, for example, you have a very large community and you have, let's say, over 500 homes. It's going to be really hard to first get a quorum, whether or not your quorum is a majority. And if you're in a condo association, you have to go by the quorum requirements that are in your documents. If you're a homeowners association, if you have 30% present, then you have a quorum. And if that number is lower than what's in your declaration, you can use the 30%. So again, going back to the example, if you have over 500 homes and you need at least a majority of the quorum, and you don't get it, you can temporarily adjourn the meeting to a future date, but you have to state in the meeting when you're going to be holding that continued meeting. Okay, you have to have the date, the time, and the location already planned out. So make sure that you do that before you start counting. Also, do not read the results yet if you don't have a quorum. A lot of board members make that mistake, and they're giving everybody a tally before it's actually closed out. So don't do that, and don't let your boards do that either. So if you still require more votes and you need to get more votes to either get a quorum or to pass it, then you can continue the meeting as many times as you want up to that 90-day period from the first meeting. And the reason for that is because your proxies expire in 90 days. So you want to make sure that you get everything counted and you have that meeting within the 90 days, because if you're 1 day late and you schedule that final meeting after the 90 days, you have to start all over again. And I had that happen to an association. They went door to door, they had a committee, and they got the votes, but the manager had scheduled the meeting 1 day late from the time that the first meeting was held, and they had to do everything all over again.
I think that one common thing that does come up with community associations are board members' misuse of power. And just so everyone knows, we are going to try to do some touching on self-dealing. Nicki, do you want to touch on any of that before I go on to the next question? There are so many times where a board member does something thinking that, maybe they have their heart's in a good place with it, but it could be considered self-dealing.
So board members and self-dealing, just remember, conflicts of interest will arise if you're hiring the board member or their company to perform services for the association. That's when the conflict of interest would come up. But let's say, for example, it's a board member's cousin that owns the business that is going to be bidding on the project. That's not a conflict of interest, and the board member would not have to recuse himself from the decisions of the board. So just remember that your conflict of interest issues should be directly related to the board member. So let me give you another example. We have a proposed amendment where it's going to change the leasing provisions, and it's going to make it a little harder to rent in the community. If the board member has a property or several properties that is in the community and they own them and they're renting them out, you don't have to ask that board member to recuse himself from voting on this just because he has a personal stake in it. So that's where a lot of the confusion happens with the conflict of interest issues. So just remember that it's got to be financially tied to the board member.
Well, and I could see where, let's say many cases, a board is trying to save the association some money. So they say, you know what, Margaret's our treasurer of the association. Her husband is a handyman. We're going to pay him to do this or that. Do you say I would think that a lot of times from a legal standpoint, you want to stay away from that. Is that correct?
I mean, it depends. If you can't be unbiased about it, you don't have to automatically recuse yourself. If you can make a fair and impartial decision, then it's okay. Again, we're talking about the husband, and if the board feels that maybe this board member should recuse himself and they make that decision, then they can do that. But I don't think that it would be to such an extent that they would have to be removed from the board meeting when making this decision.
And we do want to make a note that you guys want to make sure that's documented in your meeting notes if that person has recused themselves from the vote.
And that's another good point to make, your meeting minutes. Remember, your meeting minutes are the official records of the association, and it's recording what happens in that meeting. So you want to make sure that there's enough detail in the minutes to verify what it is that happened at that meeting. And they are official records of the association.
Nicki, I get accused sometimes of our board president. I go into too much detail on my meeting minutes. Is there such a thing?
Too much detail. Yeah, I've seen that too, where there's too much detail. And let me give you an example, actually. The one example was I had a closed board meeting. We were discussing litigation, and the secretary was taking meeting minutes, and she was writing everything down, down to my strategy. And when she produced a copy of the minutes, I was like, no, stop. You can't do that. Don't publish that. So just remember that you don't want to put anything in there that's confidential, no personnel information. You want to keep things by property address. You don't want to single out any homeowners as far as names are concerned when it comes to collection issues and things like that. But be careful that you're not actually including confidential information or privileged information in your meeting minutes when they're drafted.
Okay, and you know what else? That goes back to the recording of the meetings. For people like me who are not very tech savvy and have to learn the hard way, you can always pull out your cell phone, and there's always an audio app there. I think all of them come with an audio app. If not, you can find one for free. And I recommend recording the meeting if you're taking notes, because that way, if you're the one that has to record the minutes, you have something to go on. But when you do that, Nicki, how should you state that the meeting is being recorded? What's the proper procedure there?
First, you should get advance notice that the meeting's going to be taped or recorded. And then at the beginning of the meeting, whoever's the chairman of the board or whoever's running, facilitating the meeting should disclose up front.
Okay. I mean, do you think it's a bad thing to record the meeting?
Excuse me?
Do you think it's a bad thing to record the meeting?
No, I think it's great. Gives you a
I do too. I think it. Yeah, and you can save it. One thing that we do, especially here since the pandemic has started, we've used that freeconferencecall.com. So for you guys that have, if you're not using like a Zoom platform, or I think there's a Google Meetup thing you can use, it's very similar. Freeconferencecall.com has a conference section to where you can actually share documents. You can share your computer screen. You can all call in, and you can set it up to where it records your meetings. So if you guys are worried about that type of thing, I recommend that, because you can save those into their website. You can download the actual audio recording if you need to, and then you can lock it on your system so that no one else can access it, only you. I highly recommend that if you guys are already using something like that. All right, so let's see.
We have two questions, Carrie.
Oh, okay.
Let me get to them. Hang on. Okay. Hi, Janet. How are you? I'm going to read your question first. Okay. If it's a conflict of interest for the board member to obtain a bid from a company that employs his wife. No, he did not advise the board that his wife worked for the company. Oh, that's not good. You need to disclose it. You need to disclose it to the board before the bid is going on. And that would probably be an indication that there is some sort of conflict if they're not disclosing it to the board. So if you're ever in that situation, where you have a board member that is could have a potential conflict of interest, they should disclose it to the board before the meeting has to make the decision takes place. Okay, I have another question from David Middleton. What can be done about boards who hire unlicensed and uninsured people to work on common areas? What about shareholders who hire the same in co-ops? Yeah, that's bad. There shouldn't be that type of activity going on. I would actually recommend that you amend your declaration to say that all vendors who are hired have to be licensed and insured. The board is going to get in terrible situation trying to be cheap on the front end, and it's going to cost them a lot of money in the end, obviously. But boards will be boards, and they'll do what they think they can do. The only thing managers can do is to cover themselves, follow up with an email, and let them know. I highly recommend that you do not hire an unlicensed contractor. You could lose your insurance, yada, yada, yada. But they're going to do what they do. I'm frustrated as well sometimes.
So David, Hi, this is Carrie with BMI. I actually am a retired insurance agent for commercial, and I did a lot of community associations. I can tell you that one problem that could occur with this is that the association could be audited and charged for the payroll that was paid. If anybody gets hurt on the job, it could kick into a workers' comp claim. And those are the types of things that are also going to trigger cancellation notices by insurers, because they do. I would guarantee you might want to check all of your contracts with the insurance, call your agent. There's probably wording in there that requires them to hire licensed or actually insured subcontractors. And that might be your go-to and way out, that they have to follow that rule, or else it voids their insurance contract, which voids their insurance policy. Okay, I'm off my soapbox now.
I think also, let me point on that as well. I've seen some management contracts with the board and the association that indicate that they will hire licensed contractors. So that's also another avenue where they could be in breach of contract with your management agreement if you put that in there. Okay, we got all the questions on Zoom, Carrie. So do we have any other questions?
I do. Hang on. I'm maneuvering my screen right now. Too many screens. Okay. What have different opinions? Well, we have different opinions on the Architectural Review Committee here at our Homeowners Association. Some say that they are required by law to post their agenda within 48 hours, since the Architectural Review Committee reviews and approves applications on behalf of the board and is bound by the same laws. Some say that the committee isn't the board of directors, so it doesn't have that requirement. Who is right in this situation?
Committees that are reviewing applications, architectural review committees, they have to notice their meetings just like board meetings. They have to give 48 hours notice. Whenever you're going to be handling issues regarding the use of someone's property, then yes, you have to notice the meeting, even if it's just a committee meeting, because they have the right to question the committee or question the board in regards to whatever it is that they're having approved. So make sure that you do notice your meetings for committees.
Do we have any other questions from our live viewers right now? I want to take a quick time to tell you guys that we have previously recorded webinars with Nicki. We've done collections, we've done emotional support animals, and we've also got some hurricane prep information. They can all be found on our website at www.bmitampa.org/education. So if you just go to bmitampa.org, you will find it under our education tab, and just scroll down there. We've got the live webinars, the recorded webinars there. We also have some documents attached there that reference back to the webinars or that are discussed within the webinars. Nicki, is there anything else that you wanted to add?
You can actually watch these webinars as well.
Yeah, I'm not going to give you we can't give a CE credit for just watching it, but it's, you might watch some of these and decide this is perfect for this board to watch, or a specific, or just to send out to all of your community association board members and say, you guys might want to just watch this just to get savvy on this specific topic, because we know it comes up, or it has come up in the past.
Okay.
All right, well, we want to thank everyone for joining us today. And Nicki, did you have any last minute comments?
Just review your declarations before you do anything. It's very important. Just make sure that before you do something, or the board's going to do something, that you check the declaration and the bylaws to make sure that they have the authority to do it. A lot of these questions are centered around what can and can't be done. And your governing documents, remember, they're the constitution of the community. I got one question. Hang on, Terry. Again,
Yeah,
David.
I think we overlooked David's question.
I sent in a
about
question.
registered agent.
Has this been answered? No, I don't think I answered anything. Can a corporate officer change without board approval? No, that's a great question, David. You can't. You have to, the board has to vote to rearrange the officers. And if you're going to remove an officer, you're not really removing them from the board. You're just changing their officer position. You're not removing them from the board because you can only remove board members through recall. And a lot of board members don't understand that because sometimes the bylaws indicate that they have the right to remove board members, either because they don't attend a certain amount of meetings or what have you. David said the registered agent is in residence.
I don't know what that means. Not. He's not a resident?
He's not a resident? Okay. So, David,
So are you saying you want to remove the registered, they want to remove the registered agent?
Yeah, that should be a board decision. But remember, you have to get consent of the registered agent for them to become one as well.
But Nicki, let's say you have a re-election or an election, and you have a couple of officers that have been re-elected. And so one you want to bump up. Let's say she's treasurer and you're going to bump her over to vice president. All of that has to be voted on or just recorded in the minutes?
Remember, you're going to have your organizational meeting after the election, and that's where they normally assign officer positions, as you're doing it among the board and everybody's voting on it. So you could record that, yes. Is it necessary? No, you don't need to, but at least make sure that there were meeting minutes taken when all the officer positions were being assigned.
Okay. David, did we answer your question properly? You might be typing more. Feel free to type more. We have time. You guys are giving some great questions today.
Agent is not, okay. What do you mean by the agent?
Okay, let's define registered agent.
You mean in Florida?
Hmm? So you're saying like the division of corporation shows them as the registered agent on file.
I see what you mean. Yeah, for your registered agent, you need to have someone domiciled in the state of Florida. I mean, if you're going to be doing a registered agent as far as, let's say, in another state, your requirements are not being fulfilled. There's actually companies that are in business to be registered agents for corporations that are actually in other states. So it has to be Florida agent.
Okay. All right, this is the last call for questions. You guys type up. Oh, got one. Ingrid, our building board of directors interviews the prospective owners / tenants, and they have to fill out an application prior to this interview. Is this application a legal document if they lie on it?
It depends.
Oh, if they misrepresent themselves.
Well, if they lie on the document, well, first of all, the application itself should be kept on file, but it would not be considered an official record if it contained personal information of the potential owners or tenants. Because if your governing documents allow for background checks with the approval of the board, you're going to have social security numbers on there, so you wouldn't be able to produce that information. If you wanted to produce that information, you would have to redact that document so that all of the personal information, addresses, social security numbers, and things of that nature. So in my opinion, anything that doesn't contain any personal or confidential information should be considered an official record of the association. So to answer your question, if you have this confidential information in that application, I wouldn't consider it part of your official records because you can't disclose that information.
So this would be a good time to discuss renters. As far as the bylaws go, the bylaws have to state, and correct me if I'm wrong, when it comes to renting your unit out, there has to be something in the bylaws that states how many units within the association are allowed to be leased out. Is that correct?
Not necessarily. You would normally put a provision in the declaration that it's considered a leasing cap. But if you don't have it in your declaration, then you can't have a leasing cap. And what I normally would recommend is that you can't have any more than, I believe it's a majority or 50%, because then you're going to have problems getting lenders to provide loans to homeowners for residential properties. If you're over a certain percentage, then they're going to consider an investment property or a leasing, a leased property. So be careful.
That's what I was thinking.
Yeah, I would actually put, if you're having an issue with rentals and there's too many, and you're going to get into that situation where it's not going to be considered a residential property anymore, amend your documents so that you can cap the amount of tenants or leasing that goes on in the community. And then you might actually have to have a waiting list. So all those provisions that we're talking about have to be in the declaration, so you may have to amend your declarations.
Is there anything that you would recommend a board be cautious of when they're, going back to her question about they're interviewing owners and tenants prior to allowing them to purchase a property or rent a property on the association grounds? I could see where this could be scary sometimes because you don't want to misuse words and things like that. Any kind of advice you want to give?
Well, here's one thing for tenants that you should never, ever ask is their credit score, or whether or not, they have been evicted for non-payment, because the remedy for the association would be to go after the owner, not the tenant. Hang on, I've got some questions here.
We got a couple, but we've already answered them.
Oh, okay. Got it. All right. Going on about the leasing application, don't ask any credit questions because the owner and the tenant have their own arrangement for payments of the lease. And the association has a remedy to file a lien foreclosure against the owner. And you also have another remedy where you can intercept the rent payments from the tenant. And if the tenant doesn't turn them over to the association, then the association can act as the landlord and evict that tenant. This is all under Florida Statute 718-116, and you can also use this remedy for homeowners associations.
Can the board require, like there was a property, a newly built condo association, well, there were townhomes in St. Pete. And I recall that whenever someone was interested in renting, the board made them go through a local realtor to do all of the leasing process because most of the unit owners were out of state. Mm-hmm. Have you ever heard of that?
Where they would only use a certain realtor?
Well, or that they had to use a local realtor because they're not within the state of, they're not in the state of Florida. So to have somebody that was local to be able to handle the whole tenant issue and everything, mm-hmm. It makes sense. I mean, it makes sense, but I just don't know if you can require all of the unit owners to use a local realtor for rental purposes.
I mean, that's a very odd provision to have in a declaration. I mean, I understand having a local realtor, but are we talking local as far as somebody in Hillsborough County or Pinellas County, or are we talking, somebody that's down in Fort Lauderdale and you're selling a property?
No, I mean like, yeah, local within the same county. But I was just kind of thinking that it makes sense because you have so many landlords that are not local to fix issues or to have repairs done and all that kind of stuff. So to have someone there that was actually overseeing all that and could speak to the board whenever there was an issue would be good, but I guess it's something that would be difficult to maintain.
It's a very odd request.
I'm overthinking it. Okay, so I'm overthinking it. Okay. David did have another question about bylaws that I don't know if we answered or not. He said, if bylaws have been filed with the county, do all new amendments have to be filed to be enforced?
Can you say that one more time, please?
Yeah, I'm sorry. If bylaws have been filed with the county, do all new amendments have to be filed to be enforced?
Yes, absolutely.
Okay. Going back to that rental thing too, you guys, that brings up another insurance issue too. So whenever you guys are coming up with stuff that's giving you a hard time, don't forget to include your insurance agent in some of these questions as well as your attorney, because if there's always something that can help you out there. I'm just going through the questions to see if we got them all, and I think we have, Nicki.
Okay.
Yeah, it looks like we've got them all. So we want to thank you guys for joining us today. As we close out our webinar, I will be playing a video that has information on upcoming webinars that we're going to be having. And I encourage you guys to stick around and watch this so that you can see what's going on at BMI and join us for some future webinars. So we want to thank you, Nicki, with Appleton Reiss, for this great Q&A today. We want to thank all of our attendees who came in and gave some really good questions. And you guys have a safe weekend. And my last thought is, don't forget to wear your mask. So be safe, everyone.
As we all adapt to a COVID-19 world, BMI Tampa would like to thank our chapter sponsors for their ongoing support of manager education.